Clark Neely, senior attorney at the Institute for Justice, was recently in Wisconsin to speak to the Federalist Society. During his visit, he sat down with the MacIver Institute to discuss how judges are failing to uphold the Constitution by freely allowing an increase in the size of government.
The judiciary's refusal to go to bat for liberty in many settings, including particularly economic liberty, property rights, limited federal government. The judiciary basically has given up judging in these areas. And by that I mean given up any meaningful attempt to enforce constitutional limits on government power. And what became increasingly clear is this wasn't some sort of an accident, it wasn't sporadic, it wasn't happenstance. This is part of a deliberate and intentional abdication of responsibility to enforce constitutional limits on government power, leading to far more government than the Constitution permits. Probably the one that's on many people's minds right now is the Supreme Court upholding the Obamacare, the individual mandate in Obamacare, by essentially rewriting the law so that what had been a mandate to purchase government-approved health insurance now is just a choice with tax consequences. That's a preposterous interpretation of the law. It is not in any meaningful way an attempt to get the Constitution right, at least in my judgment. And it ratified the greatest usurpation of power by Congress in the last 75 or 80 years. But it's a paradigmatic example, unfortunately, of the way that courts go about their job today, which is, in many, if not most cases, they simply abdicate any responsibility to enforce the Constitution.
For the MacIver Institute, I'm Nick Novak.